everyone, welcome to the video, and we're going to be talking about policing by consent, the definition, which was provided apparently by Robert Peel, who provided 9 principles of policing, although here on the government website they argue that it was probably coming from the first commissioners of police and of the Metro Police, which was Charles Rowan and Richard Mayne. The principles which were set out in the general instructions were issued to every new police officer from 1829 were: number 1, to prevent crime and disorder as an alternative to their repression by military force and the severity of legal punishment. So it makes you wonder, as an alternative to repression by military force and severity of legal punishment, what was going on before they provided this consent to policing. Number 2, to recognise, and I'll look into that, to recognise always that the power of the police to fulfil their sanctions and duties is dependent on public approval of their existence, actions and behaviours, and on their ability to secure and maintain public respect. So they have to ensure that they've got public approval and that their actions and behaviour maintain that public approval and respect. Number 3, to recognise always that to secure and maintain the respect and approval of the public means also the securing of the willing cooperation of the public in the task of securing observance of laws. So I guess with that you could sort of assume that the willing cooperation of the public, so the public need to report crimes or suspects to the police so that the police can deal with it. So they have to be the turn to people. And with them being the turn to people, the police being the turn to people, then that removes the ability really of the idea of citizens' arrest. To recognise, number 4, to recognise always that the extent to which the cooperation of the public can be secured diminishes proportionately the necessity of the use of physical force and the compulsion for achieving police objectives. So again, it is the need of the public. Number 5, to seek and preserve public favour, not by pandering to public opinion, but by constantly demonstrating absolutely impartial service to law in complete independence of policy and without regard to the justice or injustice of the substance of individual laws, by ready offering of individual service and friendship to all members of the public without regard to their wealth or social standing, by ready exercise of courtesy and friendly good humour, and by ready offering of individual sacrifice in protecting and preserving life. Whew, that is one long sentence. Bloody hell, they wrote long sentences back then, didn't they? Okay, that's a lot to unpack. So, they should not be pandering to public opinion. Now, that's a hard one to consider because a lot of people in the alternative media believe that that is exactly what the police are doing, and there's a 2-tier police system. And I can certainly see that side of the argument. However, on the other side of the argument, because we are so split now and so divided in society right now, the other side of this argument is that there's institutional racism, which I'd agree with, but I'd also say that racism is towards white people as well. And they are arguing that there's too much deliberate policing of minority groups. And that will likely be because a lot of the in this day and age, a lot of the crimes which are committed against white people are often done by minority groups, and that is now being omitted from our mainstream media information. Even just by being here illegally, they are committing a crime against the native people. So, they're supposed to be policing this, and they've already failed at number 5, I think. But also, it says that they need to present themselves as friendly and good-humoured. So is that why the cars are dressed up in rainbows and the police are getting down on their hands and knees as they do the BLM bow on the ground? But again, in a divisive society, which we are in right now, a divided one anyway, then that just doesn't work. And they're going to have to find new ways of being friendly, courteous to all the different groups of a multicultural, very liberal minded society, without showing any kind of, without repulsing the other side, really. And I'm not even sure that they can do that, which is going to be very difficult for them. I don't envy their position. And I think also we need to be reminded of this, because if we forget what their role is, then we're not holding them to account. We're not letting them know where they're failing. And it is up to us to do that reminding, I believe. To use physical force only when the exercise of persuasion, advice and warning is found to be insufficient to obtain public cooperation to an extent necessary to secure observance of law or to restore order, and to use only the minimum degree of physical force which is necessary on any particular occasion for achieving a police objective. Whew, another long sentence. Bloody hell. Right, let's unpack that one again. To use physical force only when the exercise of persuasion, advice and warning is found to be insufficient. Okay, I think that's being used at the moment. I'm not really sure about the extent to which physical force is used with protests or anything like that, but when they turn into riots, then I do believe that police should be allowed to use physical force to prevent that, because obviously that's a crime. But then again, it depends on whether the police get wrapped up in this moment of emotions and whether they're led to use physical force on the basis that they are sort of predicting that other groups of people who are known to have been protesting could turn into rioters. Are they sort of preempting potential criminal behaviour and acting on that, or are they doing it as the force is happening? And I think they may get carried away with their emotions. But then again, so do protesters, which is why I don't attend any protests. I mean, it's an emotional situation to be in, and it can become heightened at any given moment. To maintain at all times a relationship with the public that gives reality to the historic tradition that the police are the public and that the public are the police. The police being only members of the public who are paid to give full-time attention to duties which are incumbent on every citizen in the interests of community welfare and existence. Bloody hell, these sentences. Okay, so to maintain at all times a relationship with the public that gives reality to the tradition that the police are the public and the public are the police. Now obviously there was a time when people would make citizens' arrests, and I suppose I should look into that. What was going on with citizens' arrests at the time? Obviously the citizens were taking the law into their own hands, and I suspect that the police were created to prevent that, and that would have been in 1829, that period of time, that kind of thing. So after a quick check, there were changes, and they were significant at that time, and that was lunatic asylums, and they were large hospitals, privatised hospitals, where they threw their the people who they claimed were mad. And previously they had been a community problem which only the parishes dealt with, but they'd become this industrialised situation, which is something that you see a lot with the 1800s. Everything started becoming privatised and industrialised, rather than it being about the parishes dealing with their own situations. So that will, an institutionalised, privatised madness hospital would certainly bring about the police as well, so that people conducted themselves better. That's one possibility. I'm sure there's multiple, but there's one particular path that we can look down in more detail later on. There were massive changes which happened in the 1800s, and they were huge. And then there was a massive population increase during that period of time as well. It was like a massive population boom. I'll look into that at a deeper level, because I've been looking more into 1066 period and kind of ignoring that period of time. I know that around about the 1800s we had a string of monarchs who were very much associated with the Holy Roman Empire. So I also know that the Catholic Church imposed itself within that, because that would have been like a Protestant period, a Protestant geographical location, very much against the Roman Catholic Church. And then the Roman Catholic Church paid the Teutonic Knights. They gave them funding, so then that would have meant that the Teutonic Knights became Catholic. And the Khazarian Empire, prior to that, round about the 900s and the 1000s, found their way into the Catholic Church, the Roman Catholic Church. And the Khazarian Empire was predominantly Jewish, but it had Islam. It was multicultural basically, but it was led by Jewish people, and then the white Jewish people sort of were the hierarchy of that society. So I'll look into what was going on around about the 1829 period within regards to the law. To recognise always the need for strict adherence to police executive functions, and to refrain from even seeming to usurp the powers of a judiciary of avenging individuals or the state, and of authoritatively judging guilt and punishing the guilty. Well, you see, we've got these laws written into our system now with regards to speech. So they are literally following the laws, but the laws are overreaching. And we'll look into when statute law came into Britain as well, which will take us back to 1066. To recognise always that the test of police efficiency is the absence of crime and disorder, and not the visible evidence of police action in dealing with them. Well, we have a crime increase, and then what people are arguing on one side is that the police are not using enough force when they should do, particularly I guess they mean around speech, because they also at the same time do not want force used against illegal immigrants, so and that kind of thing. So I do feel for the police, because they're in a real difficult situation, and I do consider that the issue here lies with statute laws, and we'll look at that in a minute. Essentially, as explained by the notable police historian Charles Reef in his new study of police history in 1956, it was a philosophy of policing unique in history and throughout the world, because it derived not from fear, but almost exclusively from public cooperation with the police, induced by them, designedly by behaviour with which secures and maintains for them the approval, respect and affection of the public. It should be noted that it refers to the power of police coming from the common consent of the public, as opposed to the power of the state. It does not mean the consent of an individual. No individual can choose to withdraw his or her consent from the police or from the law. And that's an interesting statement. So I would agree with that. You can't remove your consent from the law. But then which law are we talking about? Could common law or statute law? I mean, I use statute law as well as common law, so I think they're both useful. And we'll just look again at Somerset versus Stewart. This was about a slave who was on English soil, so he could not be forcibly removed to the country and sent to Jamaica to be sold. And it was Lord Mansfield decided that the state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law. Which also suggests that law is not, or statute law is not moral, which preserves its force long after the reasons, occasions and times itself from whence it was created is erased from memory. So statute law is long-standing law, and it does not necessarily, or it can be manipulated to mean have a very different definition in the present day to what it actually meant back then in those days. And all of this interpretation of language is why we are probably struggling like we are, and sort of falling apart into different groups of people, because even with religion, when it's written down, it takes on this authoritative role, and then people are trying to interpret what it means. They're trying to interpret it in today's society, in the present time. And you've got to also, and then they're saying, well, it was written up and it was done in this period of time and spoken in like 2,000 years ago, but it was written up in this year. So there's all these different interpretations sort of manifesting in these written pieces. And so it becomes very complicated and complex to try and uncode what's been written down. It is so odious that nothing can be suffered to support it but positive law. And that, to me, suggests that Lord Mansfield really disliked positive or statute law. So we'll look at English law. And we'll look at the history of it. I'll ignore the rest of it. But the history is quite interesting, because here's what it says about the common law, which I thought was interesting. Common law is a term with historical origins in the legal system of England. It denotes, in the first place, the Anglo-Norman legal system that superseded and replaced Saxon law. So we'll have a look in Saxon law, because I haven't actually looked at it. I didn't realise they had their own legal system. We'll have a look into that. But common law. This is only one professor, so, you know, I'm surprised it's got its own little feature, but I suppose they have to do this for the diversity, equality and inclusive thing, maybe, I don't know. But this professor, John Makdisi, he argues that it came from Islamic origins round about 1166, and he argued that these institutions were transmitted to England by the Normans, and I always consider Normans are a rebirth of like the Roman Empire, especially with the Khazarians entering into the Roman Catholic Church, and then the Roman Catholic Church gave authority for the Norman invasion of England, and I believe that England had become a safe space for, and along with Germany, for Protestants who lived there, and then it was sort of overtaken again by the Catholic Church. So it's interesting that it came from the Normans around about 1166, which has Islamic origins, because that really does sort of add a bit more evidence that the Khazarian Empire entered through the Norman invasion and the Catholic Church. So Anglo-Saxon law was a legal system of Anglo-Saxon England until the 1066. It was a form of Germanic law based on unwritten custom known as folk right, and on written laws enacted by kings and with the advice of their witan or council. By the later Anglo-Saxon period, a system of courts had developed to administer the law, while enforcement was the responsibility of the alderman and royal officials such as sheriffs, in addition to self-policing by local communities. Originally, each Anglo-Saxon kingdom had their own laws as a result of Viking invasions and settlements. The Dane law followed Scandinavian laws. So we'll have a look into those, because that will be interesting. Because I don't believe that we had no laws. I think that in order to live in even small settlements, then you have to have you know, laws or rules or simply agreements, things like that. Yeah, so we're going to look into HLA Hart and his philosophy around law, because I think that a lot of law is psychological as well. So we're going to look into that kind of stuff in the next video, but that was just the definition of policing by consent. I'll leave a link in the description box for all these things which I looked at, and we'll see. You can let me know what you think about it. So please, thanks for watching. Please like, subscribe and share. Thank you. Bye.